I expressly do not consent to this court's jurisdiction and do not
Well, then
any
you are
rights.
not a named party, so if you're not consenting to this court's jurisdiction, sit down.
Buckle up, folks, because what starts as a routine eviction case quickly unravels into a full-blown courtroom drama involving million-dollar properties, accusations of fraud, and courtroom power plays that'll leave you speechless. At the center of it all, a woman claiming to be just an occupant, a property tied up in multiple bankruptcies, and a judge who isn't having any of it. This is BMC Rio LLC v. Wetlow & Co. And today's hearing is about more than just possession. It's about the abuse of legal process, forged leases, and a judge trying to untangle a mess wrapped in legal jargon and emotional outbursts. You won't believe who tries to challenge the court's authority and how quickly it backfires. Stay tuned.
So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language.
Did you catch that? The plaintiff just dropped a bombshell. The bankruptcy court labeled the entire filing as part of a scheme to delay, hinder, and defraud. That is no light language. In legal terms, this is as strong an accusation as you can get in a civil housing case, and it sets the tone for what the judge is about to hear. Notice how the plaintiff meticulously presents that June 20. This isn't just about eviction anymore. It's about exposing a possible coordinated abuse of the bankruptcy system. And spoiler, the court isn't going to let it slide.
4001A3, a bankruptcy rule.
Right.
Creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years.
Now here's where the stakes rise. The court's order not only lifts the bankruptcy stay, it prohibits any refiling for 2 years. That means the usual delay tactics are shut down before they even start. This is incredibly rare and signals that the court believes this was no accidental paperwork mess up. It was a strategic attempt to game the system. If that doesn't send a message, I don't know what will. Imagine buying $1 million home, defaulting within months, and then passing it around like a legal hot potato through multiple bankruptcies. It's like house hacking gone rogue.
But the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor.
There's more. Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case.
And just when you think it can't get messier, enter Ms. Whitlow. Or should we say, exit, because she hasn't appeared at any hearings, ignored a federal deposition, and blew off a court deadline to provide key documents. That's a major red flag. Think about it. If your name is on $1 million mortgage and you're at the center of a legal firestorm, wouldn't you show up to defend yourself? Her silence speaks volumes, and the judge is definitely paying attention.
Documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Yeah, go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a
Now we're
bankrupt-
seeing the pattern unfold. Multiple people, some not even living in the same state, have filed bankruptcies listing this exact address. It's like this property is turned into a magnet for legal mischief. And here's the kicker. Ms. Banks, who's representing herself as an occupant, was actually barred from preparing bankruptcies for anyone other than herself. That's not just ironic, it's suspicious. This is turning from a property dispute into what looks like an orchestrated shell game.
And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous.
And
Wow.
here it is, the moment things go off the rails. Miss Banks stands up, clearly nervous, and tries to challenge the court's jurisdiction. That's a bold move for someone not even listed as a defendant. But what does the judge do? She shuts it down hard. You're not a named party, she says, and boom, game over. This is a textbook example of how not to approach a judge when you have no legal standing. Watch closely. This interaction becomes the unraveling moment for Banks.
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow
you
was
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work.
This back and forth about jurisdiction gets even more chaotic. Banks tries to recant her earlier statement in real time, hoping to reverse her rejection by the court. But that's not how legal proceedings work. You can't just toggle your legal status like a light switch. The judge points out, again, that Banks has filed nothing and has no contractual ties to the plaintiff. It's awkward, painful, and very revealing. At this point, the court's patience is visibly thinning and the audience can feel it.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who
We're
you
now
need.
in deep legal waters. The judge explains privity of contract, meaning unless Banks has a direct legal relationship with the plaintiff, her lease means nothing here. It's Courtroom 101. You can't sue or be sued over a contract you're not part of. If she wants to enforce anything, she's got to go after Whitlow. This is a great moment to pause and ask, who do you think is ultimately responsible here? Whitlow, Banks, or both? Drop your thoughts in the comments.
Let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
Okay.
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract.
And just like that, the judge grants the plaintiff's motion for possession and raises the stakes again. An eviction order with only 10 days to comply, plus a $15,000 per month appeal bond. Let that sink in. The defendant's original lease wasn't even close to that amount, but now, if they want to fight the judgment, they better pay up or move out. This bond is the court's way of saying, if you want to appeal, show us you're serious. That's the legal equivalent of putting your money where your mouth is.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't write any.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes.
So what just happened? In one explosive hearing, the judge dismantled a tangled web of bankruptcies, forged leases, and absentee owners. The property in question, $1 million home, became the centerpiece of what appears to be a pattern of delay and legal manipulation. The court sided with the rightful owner, BMC Rio, while putting serious legal guardrails in place to stop further games. Miss Banks, told to take it up with Whitlow, and the Whitlows, still nowhere to be found. This was a masterclass in courtroom control, and the judge made it clear, the law is not a loophole. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom
10
breakdowns.
minutes after that.
Thank you, Your Honor.
Court's